Hello students, welcome to my course. Uh, Today we are going to see about the introduction of SARFAESI Act, why SARFAESI Act was introduced, what are its salient features, and what is the most important things that you must know from the perspective of interviews and names, from the perspective of interviews and names. Um, So without any other further ado, we'll straight away go to this SARFAESI Act. And in case if you feel that anybody is preparing for this law officer examinations, and if you feel that this video could help them, please share with this video, and please support me by subscribing, liking, and any comments, any doubts, anything if you need, you can ask me here. What is the historical background of the SARFAESI Act? For any legislations that is enacted by the legislature, there must be some historical background. And why SARFAESI Act? The primary reason for the enactment of SARFAESI Act is that the normal procedure for enforcement of security, was tedious, cumbersome, and time-consuming. To be put simply, what is this what is the normal process? That is through normal legal process. What is the security? Like I said, like security or the collateral that is provided to the loans when a lender or like a bank provides loan to the borrower provides collateral, be it as a house, land, or anything as a security. Now, in case if the borrower defaults, that means the borrower doesn't pay the loan, then the bank can sell this security. Now, the process before the enactment of SARFAESI Act was cumbersome. That is, it was really huge, and only very few mortgages like English mortgages and other English mortgages and other certain mortgages at the cities can be sold without the court intervention. Otherwise, the court intervention, and we know when the court is intervening and when it is a court process, it usually takes a huge amount of time. So that was the basis. And if you want to know one thing, you can know that the SARFAESI Act was based on the Narasimhan Committee Act and Adarujuna Committee Act. Arjuna Committee Act. So this is a question for mains. Uh, you can understand this. So this is Narasimhan Committee Act and Arjuna Committee. So both these committees, the recommendation for SARFAESI Act, the major reason was to fast track the recovery process. This is a key question after the SARFAESI Act was enacted. That is, it gave the banks the ability to sell without court intervention. Now, remember, property is a constitutional right. Property is a constitutional right. And because there is no court intervention, this SARFAESI Act was challenged in the uh, Supreme Court for constitutional validity, and the Supreme Court upheld the validity of the SARFAESI Act in the Madia Chemicals versus Union of India case. This is a very Madia Chemicals versus Union of India, another mains question. Now, what are the salient features of the SARFAESI Act? It regulates the securitization and asset reconstruction, enforcement of security, and establishes a central database. So these are the three features. That is, it regulates the securitization, that is, how to sell the pooled assets of security. Next, enforcement of security interest. How security interest or the ones that is provided as collateral for the loans, and how the banks could enforce the security interest without the intervention of the courts, without the intervention of the court. Then an establishment of centralized database so that all the charges relating to the security are maintained. Now, this is something of a very important and easier thing. That is the enforcement of security interest. Enforcement of security interest, very simple. First, Section 13 to notice, it is a 60-day notice. Immediately, once the account becomes NPA, the banks provide you with the Section 13 notice. That is, they give you 16 days to fulfill the debts. And if there is any objection for the borrower, then they can send an objection within 60 days, for which the banks must reply within 15 days. So that is the borrower can object it. And in case if after 60 days and the objections, everything is taken care of, the borrower is not paid, then through Section 14, bank can sell and take possession, manage or sell his assets. And if after selling these assets, still dues remain, the bank could approach DRTs to proceed against the guarantors. And either they can sell the other remaining assets. In case if the bank does not want to use the SARFAESI Act, they can sell it to the ARCs for the bank's recovery. And remember, no civil jurisdiction. The civil court jurisdiction is not applied. And in case if in any of these processes, if the bank suffers, if the borrower suffers any injustice, then they have to approach only DRT. Is the appeals process under the SARFAESI Act. Appeals against DRT orders can be made to DRAT. So the appeals can be made to DRAT. And if the borrower wins the appeal, then they can have either repossession of the asset, compensation costs, and no claim for additional damages. So there is an appeal. Remember, the appeals are made to the DRAT. And of course, this is just an introductory class. We will see everything in detail in the coming days. Securitization under SARFAESI Act. What is the concept of securitization? Concept of securitization that you must understand. That is, it is the sale of pooled and distressed assets. It is the sale of pooled and distressed assets. And remember, securitization will also involve future receivables. So, for instance, in case there is always a practice that a borrower or a company would pledge or provide an hypothecation its receivables, book debts, profits, or plants and machineries. For instance, if a lender like a bank provides a loan based on a hypothecation of plant and machineries as a security, and the plant and machinery is not going to remain static. It's a dynamic. The more the company develops, the more the plants and machineries the company is going to acquire. And even the future receivables or money or anything can come under the concept of securitization. That is the beauty of SARFAESI Act, because this is not clearly mentioned before the enactment of SARFAESI Act in the previous legal process. Next, role of ARCs. ARCs must, that is asset reconstruction companies, they must be registered with the RBI, and they can acquire these financial assets. So, like I said, it is in the discretion of the bank. The bank can either use the SARFAESI Act to sell the securitized assets themselves, or they can sell it to the ARCs, and the ARCs will then become the secured lender or creditor, and they will, what do you call? They will sell it and get the profits, or appropriate their against the proceeds. So these assets can be sold to the ARCs by the banks. Remember, this is at the discretion. Either they can sell or they can. And investments. So there are qualified buyers. They can invest in ARCs to security receipts, and ARC realize the financial assets and returns the investments and profits. So usually, this you will not be more active in dealing with these aspects as a law officer, because this is between the qualified buyers and the ARCs. Until unless you're working on ARC, in banks, this process will not be there. Like I said, securitization means simply the sale of pooled distressed assets. Now, remember, this is very important. If there is a conflict between borrower plus bank in the enforcement of security under the SARFAESI Act, it is the DRT. But if there is dispute between the banks, FIs, ARCs, and the qualified buyers, then it will be dealt under a arbitration and conciliation act. Asset reconstruction under SARFAESI Act, like I said, securitization can happen even during the time of distressed assets. That is not necessarily the assets need not the assets of the loan need not become a NPA. But whereas when it become an NPA, when it has been turned into NPA, then asset reconstruction will come into picture. So what is asset reconstruction? Asset reconstruction is simply a process that the ARC, asset reconstruction company, takes over the assets after the declaration of NPA. After the declaration of NPA, and they become the secured lender or creditor. That is, the bank make turns an account in NPA, then they sell the assets to ARC. Once it is sold to ARC, the ARC will become the secured creditor or lender. Of course, once this has happened, the role of the bank is over. I have seen in many cases, once a bank sells the property to the ARC, the borrower keeps on talking to the bank. Look, there is no use after the bank has sold your property to the ARCs. So that is one thing that you must remember. Next, realization registration of security. There is another portal called CERSAI. This is all about having records of the security created and records of the security created.